now I'm going to jump to Yesenia's question, which I hear all the time. So it's the perfect question to start this out with. The question is, my father was denied his parole in place. What could we do? It was due to multiple attempted entries. So this is a great question. Now, excuse me, sometimes we don't know exactly why the denial is happening, even if there were multiple entries. So I'm going to give you a very technical example. If somebody tried to enter the United States without permission and was caught and sent back voluntarily, like a voluntary return by Border Patrol, where they kind of escort you back to the border. Sometimes they'll spend a little bit of time in the hielera, like in a super cold cell. They'll take pictures and fingerprints and tell them not to do this again, but they essentially put them in a van or have them walk back across into Mexico, and it's not an official deportation on the record. It's called a voluntary return. So if it was that kind of thing that happened at the border, and then the very next day they come back in, get caught, get sent back on voluntary return again, and then on the third time they make it across without a problem, 2 voluntary returns does not trigger the permanent bar, or it does not trigger the inability to complete a green card process through PIP. In a similar scenario, let's say the person comes into the United States, is caught at the border, and the Border Patrol agent is super angry. They don't want to give him a second chance. They just issue an expedited removal order. And then the next day, dad comes back in without permission. Now he's triggered this major bar that's going to prevent him from ultimately qualifying for permanent residency. So it matters what type of multiple entry or multiple attempted entry we have. If they were all voluntary returns in a very short space of time, oftentimes that's not going to be a denial reason. Sometimes immigration can get confused and mess it up, but it normally isn't. If it was a multiple attempted entries and the person has an expedited removal order, like a deportation order on their record that was given to them by Border Patrol before kicking them out of the country, then in that case, dad would not be eligible to adjust status to permanent residency based on PIP. And for this reason, USCIS may deny the application. Now, I just want to give like a third scenario in case this isn't confusing enough. I'm going to try to break it down. In the third scenario, dad comes into the United States without permission, spends a year in America working hard, goes back to Mexico, comes back in without permission. Maybe he's caught, maybe he's not. But if he's caught, voluntary return, let's say, so not a deportation. And then comes back in like a final time. So we've got 3 entries, but the kicker there, the one that's really going to cause a problem in a case like this, is that dad had spent a year physically in the United States without permission before leaving and coming back in. And so then it's not really the re-entry that causes the biggest problem. It's the fact that the re-entry happened after having been in the United States without permission for more than a year. It creates a statutory bar under INA 212A9C. And some other bars too on top of that.